it was beautiful and exactly what it was supposed to be. It's so difficult.
Judge Robert D. Hathaway lost his composure after Blake Lively's shocking stunt in court, and it didn't take a Netflix budget for the moment to go viral. She entered the courtroom with her usual confidence, only to abruptly withdraw 2 of her own claims mid-hearing, leaving everyone wondering whether the drama was a publicity move for her next Betty Boos campaign or a sign that her case was unraveling. The actress appeared in Department 84 of the Los Angeles Superior Court for what was expected to be a straightforward procedural hearing tied to her defamation and harassment lawsuit against actor-director Justin Baldoni. Although the trial was scheduled for the mid-2020s, the mounting volume of filings and counter-motions since late 2024 had required her presence. The day's agenda was supposed to focus on clarifying her withdrawal of 2 claims, one for emotional distress and another for intentional infliction of trauma. But as the morning unfolded, it became anything but routine. Tension filled the courtroom when defense attorney Elan Jarapilo, a veteran known for her role in the Anna Nicole Smith probate case, filed a motion to compel Lively's medical records from 2022 to 2025, arguing that any genuine claim of emotional distress must be supported by corresponding psychiatric or therapeutic documentation. This wasn't a fishing expedition, she asserted. It was a basic evidentiary requirement. But rather than comply or request a protective order, Lively's team made a sharp and unexpected pivot. Her solicitor, Raymond Keller, calmly announced that they were withdrawing both emotional distress claims entirely, stating that they would instead focus on the more egregious sexual misconduct elements central to Lively's case. The explanation was brief, polished, and curiously detached, more like a press release than a legal statement. Judge Hathaway, a seasoned Californian jurist known for his no-nonsense approach, immediately sensed something amiss. He frowned, leaned forward, and interrupted the proceedings. His voice carried authority as he reminded the courtroom that if it was to consider allegations of psychological trauma, it required actual proof. "You don't get to make headlines," he said sharply, "and then walk back allegations the moment you're asked to substantiate them." His rebuke sent ripples through the courtroom as reporters from The Hollywood Brief, Deadline Legal, and TMZ Trials and Laws shifted in their seats, capturing every word. What had begun as a routine administrative hearing had transformed into a public reckoning over Blake Lively's credibility. The question hung heavy in the air. Was this a strategic legal maneuver or a retreat from claims that couldn't withstand scrutiny? Judge Hathaway's tone made it abundantly clear he suspected the latter. His frustration reflected a deeper judicial concern, the manipulation of the court of public opinion versus the court of law. For years, celebrities have used litigation to shape public narratives, but Hathaway's reactions signaled that he would not allow his courtroom to be turned into a public relations stage. The exchange not only undermined Lively's case, but also reshaped how her lawsuit was perceived beyond the courtroom walls. In less than an hour, the hearing shifted from a procedural formality into a defining moment that left the actress's reputation and her entire legal strategy hanging in the balance. Under California Civil Code Section 3281, plaintiffs may pursue damages for mental suffering, but only when supported by legitimate evidence. A claim of emotional distress without substantiating documentation isn't merely weak. It's an abuse of the court's time and the defendant's resources. Defense attorney Ellen S. Jarapilo seized on that point, and her motion cut directly to the heart of Blake Lively's credibility. The unspoken implication was damning. Either Lively's team never had any evidence, or they feared what that evidence might reveal. And in that silence, the absence of proof spoke louder than the emotional claims themselves. What made the spectacle even more striking was its timing. Just 2 weeks earlier, Lively's public relations team had embarked on a media blitz, with interviews in Variety and Vanity Fair portraying her as emotionally shattered and psychologically strained by the alleged harassment. She had publicly described sleepless nights and crippling anxiety. Yet when asked to produce tangible proof of that trauma before the only institution that truly mattered, the court, she abruptly withdrew her claims. The contradiction was glaring, and Judge Robert D. Hathaway didn't miss it. "Statements made to the media carry no legal weight in my courtroom," he said sternly. When legal reality collides with celebrity PR, which version survives? His words landed like a gavel strike, echoing the growing skepticism among legal observers who saw through the performance as tensions rose. Cracks within Lively's own legal team became painfully visible. While lead counsel Raymond Keller attempted to redirect focus toward the sexual misconduct allegations still under review, his co-counsel Vanessa Ortega appeared visibly disoriented, rifling through case files and whispering frantically to junior associates. It was evident that the decision to withdraw the emotional distress claims had not been properly discussed within Lively's legal team. The move appeared impulsive, even unilateral, casting further doubt on the team's cohesion and the overall foundation of the case. Observers in the gallery exchanged uneasy glances. If a plaintiff's own lawyers couldn't remain aligned on strategy, how strong could their argument truly be? The situation continued to unravel when Judge Hathaway, visibly irritated, issued a warning with chilling precision. He reminded Keller that any future withdrawal of claims without proper evidentiary justification would trigger a Rule 11 review, a disciplinary measure designed to penalize parties engaging in frivolous or bad faith litigation. For a celebrity plaintiff like Lively, such a sanction would mean far more than procedural embarrassment. It would amount to a career-defining public condemnation. Then came the breaking point. As Hathaway slammed his gavel, the atmosphere in the courtroom shifted. His voice, sharp and deliberate, reverberated through the chamber. "This is a court of law, not a publicist's rehearsal room." It wasn't hyperbole, it was an accusation. Lively's last-minute withdrawal of her emotional distress claims at the exact moment she was asked for proof didn't resemble strategy. It looked like orchestration. After months of enduring what he clearly viewed as celebrity theatrics, Hathaway's patience had finally worn thin. What followed was not a discussion, it was a judicial reckoning. "If your client was medically traumatized," Hathaway demanded, "where are the evaluations? Where are the therapist affidavits? The therapist affidavits. Where is the trail of evidence?" Each question sliced through the courtroom's silence like a blade. When Keller attempted to deflect with procedural jargon, Hathaway cut him off cold. "This court does not exist to rubber stamp your headlines." The warning was unmistakable. Continue this pattern and sanctions would follow. Rule 11 of the Federal Rules of Civil Procedure is no mere formality, it's a legal grenade. Its enforcement punishes attorneys who file false or misleading claims. Hathaway made it clear that if Lively's withdrawn filings were found to be fabricated, her legal team could face severe consequences, including monetary penalties, case dismissals, or even disbarment proceedings. The message to every reporter and legal analyst in attendance was crystal clear. This was no longer about a single dropped claim. It had escalated into a full-blown credibility audit. Hathaway had effectively placed the entire case under a judicial microscope, and any inconsistencies within it would soon be exposed. By that afternoon, the court issued a formal order. Hathaway demanded a full transcript review of all filings made by Blake Lively's team since December 2024, including affidavits, motions, public statements, and evidence logs. Sources inside the courthouse later confirmed to the Daily Jurist that Judge Hathaway had privately requested a cross-match between Blake Lively's public media statements and the legal language used in her filings, a move that signaled growing suspicion of coordinated misrepresentation by a celebrity whose image had long been built on control and composure. The development was devastating. What had begun as a straightforward defamation suit had now spiraled into a legal inquest into her honesty itself. The unspoken question lingered over the courtroom and beyond. If her claims of emotional trauma could not withstand scrutiny, how much else in Blake Lively's story might crumble next? The revelation that Lively's legal team may have manipulated the court system to fabricate or exaggerate claims for reputational leverage sent shockwaves through both Hollywood and the legal world. When a celebrity's media strategy becomes indistinguishable from their litigation strategy, one must ask, has the law itself already been compromised? The fallout was immediate. That very afternoon, Justin Baldoni's legal team filed an amended counterclaim against Lively, accusing her of strategic defamation for financial advantage. Central to the counterclaim was a meticulously constructed timeline featuring Lively's interviews with The Cut, Entertainment Weekly, and Vulture. In these appearances, she made damaging statements about Baldoni, remarks that never appeared in her official court filings and therefore had never been subject to cross-examination or judicial scrutiny. The implication was damning. She had allegedly used the press to defame him outside the bounds of the courtroom. Legal analysts were stunned. Could this be the first time a celebrity faces a defamation countersuit within their own defamation case? The legal community reacted with alarm. Professor Talia Jennings, a respected litigation scholar at UCLA School of Law, told the Daily Jurist, "If Blake knowingly fabricated or exaggerated any claim under oath, that's perjury. And if her team helped build that narrative, it borders on obstruction or conspiracy." Jennings' warning was not theoretical. Under the California Penal Code, perjury in civil cases, where false statements materially influence proceedings, constitutes a criminal offense. What had once been a glamorous civil dispute over alleged workplace misconduct was now morphing into something far darker, a potential criminal investigation. In response to the chaos, Judge Robert D. Hathaway imposed an unyielding discovery deadline, ordering both sides to submit all remaining evidence, emails, text exchanges, therapy notes, witness depositions, and even production security footage, within 14 business days. The demand was not a procedural formality. It was a stress test. Hathaway wanted to see which side, when pressed under threat of sanction, actually possessed proof to back their allegations. Legal experts predicted that this accelerated timeline would expose weaknesses on both sides and perhaps reveal the ultimate truth hidden beneath months of theatrics. As deadlines loomed, the courtroom drama exploded across the digital world. Within hours of Hathaway's outburst, public sentiment turned venomous. On 2nd June alone, the hashtag #HonorBlakeLivelyLies dominated social media for over 7 consecutive hours, racking up more than 820,000 reposts before midday. What began as curiosity over her withdrawn emotional distress claims had metastasized into open ridicule. Memes flooded the internet, contrasting Blake Lively's tearful red carpet interviews with captions like, "Oscar-worthy but not court-worthy." For the first time in her career, Blake Lively found herself trapped in a story she couldn't script or control. When the fans who once idolized you become your prosecutors, who do you turn to? The backlash didn't stop at social media mockery. BuzzFeed Legal published a blistering editorial titled, "Blake Lively, the Amber Heard Playbook Revisited," drawing parallels between Lively's withdrawn trauma claims and Amber Heard's infamous 2016 deposition scandal, in which emotional testimony later unraveled under cross-examination. The article compared side-by-side screenshots of Lively's televised interviews with excerpts from her court filings, exposing glaring contradictions. The implication was unmissable. This wasn't merely bad optics. It was potential perjury turned viral content. Could any public narrative survive when its inconsistencies were trending worldwide? By evening, the controversy had reached a boiling point. A leaked text thread, allegedly exchanged between Lively and her longtime PR manager Stephanie Jones, began circulating across celebrity watchdog blogs and independent legal outlets. In one message, Stephanie appeared to write, "Drop it. We'll win hearts with a harassment angle." If authentic, the leak suggested deliberate coordination between Lively's PR and legal teams to manipulate public sympathy, a revelation that could devastate her credibility in both courtrooms, judicial and public alike. By nightfall, the verdict from the court of public opinion was clear. Blake Lively's case wasn't just collapsing, it was combusting. If authenticated, the leaked text message would confirm what Judge Hathaway had already suspected, that Blake Lively's emotional distress claim had never been intended for trial, but crafted purely for optics. The PR firm Jones Works, already under scrutiny for its involvement in several high-profile celebrity lawsuits, declined to comment, but its silence only deepened speculation. When your own publicist treats legal filings like tabloid headlines, what does that say about the truth they're meant to represent? The data painted an even bleaker picture. According to YouGov Celebrities, Lively's public favorability rating plummeted from 64% in April to 41% in June, marking the steepest decline of her career, an even sharper fall than Ellen DeGeneres' during her 2020 workplace scandal. Major sponsors began quietly distancing themselves. Maison Dulu, the luxury fashion house that had cast Lively as the face of its 2025 spring campaign, erased all promotional material featuring her within 24 hours. Hollywood's message was unmistakable. It wasn't waiting for a verdict. Blake Lively had become too radioactive to touch. How quickly does fame curdle into fallout when silence no longer protects you? In an urgent bid to regain control of a spiraling narrative, her legal team hastily arranged a press conference outside the Los Angeles County Courthouse. Her lead attorney, Raymond Keller, faced a wall of cameras and insisted that his client had every right to narrow her claims, describing the move as a strategic recalibration, common in complex litigation. He dismissed the media speculation as irresponsible and sensationalized, but the defense rang hollow. Reporters weren't interested in legal nuance. They wanted to know why the emotional claims had disappeared overnight. Keller's evasive responses sounded less like confidence and more like crisis control. Could a press statement really undo what an open courtroom had already revealed? Behind closed doors, the fractures within the defense deepened. Sources close to the case reported growing tension between Lively and Keller. The attorney had privately warned that he might withdraw representation if she continued making impulsive decisions unsupported by legal grounds. Insiders at Keller & Marx LLP admitted that the firm's senior partners were increasingly alarmed by the reputational damage, fearing their practice would be remembered as the one that gambled its credibility on a collapsing celebrity. When even your own lawyer begins to distance himself from your defense, what hope remains? The unraveling didn't stop there. Efforts to bring Taylor Swift as a character witness, once hailed as a masterstroke of PR, imploded almost as soon as they began. Though Swift had privately expressed sympathy for Lively back in 2020, her team reportedly withdrew from involvement due to what insiders described as unmanageable reputational risk. Swift's testimony had been intended to support Lively's account of toxic behavior on the 2023 It Ends With Us set. Yet her abrupt withdrawal sent a different message entirely. Even Blake's most powerful allies were stepping away before the fallout consumed them too. When your most loyal friends start walking away, how long before the ground beneath you collapses? Yet the most dangerous development wasn't the shifting tide of public perception. It was legal liability. Lively's past statements, both in sworn filings and televised interviews, were now being scrutinized for potential defamation. Keller & Marx LLP reportedly hired external counsel to determine whether any of her withdrawn claims could constitute knowingly false statements made with malice, exposing her not only to Baldoni's counterclaim for damages, but to potential malicious prosecution penalties as well. Behind the scenes, the firm began exploring a partial disengagement strategy, stepping away from representing her in matters that might jeopardize their own professional standing. Then came the breaking point. Barely a day after Hathaway's last hearing, reports surfaced that a formal judicial ethics referral had been filed against Lively's entire legal team. According to court documents obtained by the Daily Jurist, Judge Hathaway himself had sent the referral directly to the California State Bar, triggering a professional conduct investigation into whether Lively's team had acted in bad faith. The move was unprecedented. Such referrals are almost never issued before trial and underscored the gravity of the court's suspicions. This was no longer about procedural missteps or sloppy filings. It was about potential manipulation of the legal system itself. The mechanism invoked was Section 128(5) of the California Code of Civil Procedure, a rarely used clause authorizing sanctions for tactics pursued in bad faith. When a judge refers your case to the bar, the question becomes unavoidable. Is this still a trial, or the beginning of your own disciplinary reckoning? Under Section 128(5), a judge may impose monetary or disciplinary sanctions if a party engages in litigation that is entirely without merit or pursued solely to harass or delay. Hathaway's decision to invoke it caught Blake Lively's attorneys completely off guard. According to the court transcript, the trigger was her team's sudden withdrawal of emotional distress claims immediately after leveraging those same allegations to dominate headlines and generate public sympathy. In Hathaway's eyes, this wasn't litigation. It was manipulation. Can a plaintiff publicly present herself as a victim, then quietly abandon the claim in court without consequence? The financial implications were severe. Jordan Metz, a litigation analyst and former district court ethics advisor, told KTLA News that Lively could face up to $50,000 in civil penalties if found to have misled the court for strategic gain. But the real issue wasn't monetary, it was precedent. Metz warned that if a celebrity were formally sanctioned under Section 128, 5 for using the justice system as a publicity weapon, it could permanently alter how defamation and harassment cases are handled in Hollywood. Overnight, Lively's lawsuit had shifted from a star-studded civil dispute to a full-blown ethical scandal. What happens when a high-profile pursuit of justice becomes a cautionary tale of courtroom manipulation? The scrutiny didn't stop with Blake. Her attorneys suddenly became the subject of heated debate on legal panels nationwide. On a special edition of Court TV Live, former appellate judge Lynn Carmichael stated bluntly, "If this team